Okay, today we're joined by Dylan Horenfeldt, who's a litigation associate here at Mills. Dylan, welcome.
Thanks, Edna.
So, Dylan, you recently wrote an article which is a very interesting reminder of the principles of contract and contract formation and asks the critical question of when is a contract actually formed and becomes binding. And it's the case of Stribling and Starbucks. So, to start with, can you tell us what this case was about?
Yeah, and this case is a reminder in multiple ways. Essentially, an employee of Starbucks reached an agreement, severance of sorts, to end their relationship with the employer, and agreed to several different terms, along with the exchange of a release between Starbucks and himself. Um, when he received a copy of the release from Starbucks, he noted a couple discrepancies between what they agreed to and the release he received. He notified Starbucks, and Starbucks very quickly thereafter revised and provided him the release that had actually been agreed to. When he received that release, the employee took the position that the severance agreement that had been reached with Starbucks had been breached. He therefore didn't have to sign the release, and he launched a claim against Starbucks for essentially wrongful dismissal and the damages flowing from that. And the court, in dealing with this, essentially found that no, Starbucks had done exactly what it was that they had agreed to do. They had done it, performed in relation to the contract, and it was in fact the plaintiff or employee who had failed to perform. And the reminder here is this: it isn't the signature at the bottom of an agreement that formalizes a contract, at least not in most cases. An agreement can be reached well beforehand if the parties have a meeting of the minds on the essential terms of the contract. And something like a release is simply contemplated by that agreement. And ultimately, the court upheld the agreement, and so the claim was dismissed against the employee.
And that goes to this fundamental understanding that we have of what is a contract. Most people think, well, I have a binding contract when I sign on the dotted line. And what this case says is no, actually, a contract is formed much earlier than that. So if somebody's negotiating a contract, for example, so at what point then, based on this case and the case law, is a contract formed?
That's a great question. And if you're concerned about that in your line of work or business, that's where you certainly want to come to our firm, and we can help you advise, right? Because it really is important to make sure that you haven't agreed to a contract when, in fact, you might have, and you're not even aware of it. Now, ultimately, it depends. And that's always the classic lawyer answer. Contracts can be really simple. I give you something in exchange for something else, or they can contemplate hundreds of things having to be completed. Really, it is up to the parties having agreed on those things. And so if the evidence is ultimately shown that no, they didn't really have the same intention, or party A was saying they wanted something, but party B thought it was something else, if there's not a meeting of the minds on those key terms, you don't have a contract. But it's important to be live to the risk of making sure that you're not bound by something if you're not prepared to actually, go ahead with it.
And also in this era of emails and negotiating by email, I think this case stresses the importance of what you are writing in emails, right?
Definitely. In this case, the acceptance was by the employee by way of an email. It wasn't a signature, that he had done on, with blue ink on a piece of paper. But because Starbucks communicated an offer, the employee can respond with accepting that offer. Right then and there, the contract was agreed to and done as far as the court was concerned. And this isn't unusual. That's exactly the principle that courts have upheld for hundreds of years in the common law, but it's an important reminder for clients and lawyers when dealing with their clients to remind them that ultimately they are bound by what they say or type or even communicate over the phone.
Well, thanks, Dylan. That's it's a very interesting topic that I'm sure we can talk about for many hours, but gives us a lot of food for thought. Thanks.
Thanks, Ed.